This video is on the YouTube channel of the Miami Valley Fair Housing Center. My name is John Zimmerman, and I am the Vice President. Welcome to this segment of a recorded live class on the 2022 Reauthorization of the Violence Against Women Act. Our next section about VIWA is housing protections specific to recipients of HUD programs and significant people in their orbit, continuum of care, emergency shelters, and the role of service providers. So applicants for and tenants of HUD housing programs who are victims of violence are eligible, and it's not limited to women. It's available to all without regard to sex, gender identity, or sexual orientation. Also, guest, unassisted, unreported household members, and live-in aides may be eligible for protections limited to tenants. Guests are protected by the right to report. And I'm going to go over that's a new section in VIWA that talks about the right to report. A tenant can request protections if a live-in aide is a victim, including an emergency transfer for the household, and individuals affiliated with the tenant who face adverse housing decisions as a result of VIWA violence may also be protected. So the protections is a very broad umbrella. Think of it as a big rainbow umbrella, and everybody in someone's orbit is probably included. So continuum of care program requirements. So a permanent housing program's rental contract, lease, sublease, or occupancy agreement must be for a term of at least 1 year. So our rapid rehousing landlords, we need to have terms of 1 year, automatically renewable for terms that are a minimum of 1 month long, except on prior notice by either party, and terminable only for cause. Also, in all of these programs, the program participant cannot be denied or terminated or evicted from housing due to their status as a survivor of DV or due to criminal activity directly related to domestic violence, dating violence, sexual assault, or stalking acts, or threatened or that have been threatened or committed against them in the home. So an incident of threatened or actual domestic violence, dating violence, sexual assault, or stalking against the program participant cannot be grounds for claiming the participant has engaged in a repeated and serious violation of a lease or as good cause for terminating their assistance, tenancy, or occupancy rights. So there's a case out of Brooklyn where a victim's ex-boyfriend continued to harass, stalk, and threaten her after she ended the relationship. And he'd come into her apartment in the middle of the night, banging on the door and yelling. And the building security guard called the victim, uh, 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 was unable to, get with the abuser and get that abuser to stop. So they called in the police. And then a week later, the abuser came back to the building and confronted the same security guard and shot at him. Okay. So we're thinking, oh my gosh, this is time for eviction. But the victim was served an eviction notice from her Section 8 landlord based on this incident. But the victim filed a motion for summary judgment, which asserted defenses to eviction under VIWA and argued that the eviction constituted sex discrimination. And she won. Okay, the parties reached a settlement under which the landlord agreed to take measures to prevent the ex-boyfriend from entering the property. So that the courts are very, very friendly. And so our landlords that are working in Section 8 and all of the other programs like rapid rehousing and some of the other homeless programs need to be aware of these things. And I hope that we can educate them. So any agreement between COC recipients and property owner landlords must include provisions that say that the owner landlord will provide the notice of occupancy rights and certification forms. So you've got to add that to whatever contract you have. So you should be doing that. PHA should be doing that with their Section 8 landlords, okay? And the recipient is bound by this part of the law to keep in strict confidence any information. So confidentiality is so important. We need to have it in those contracts with all of these participating landlords, including the fact that a domestic violence occurred and when requesting an emergency transfer. And so then also non-TBR programs must include a provision stating that any agreement between the continuum of care recipient and program participant will permit the participant to terminate the agreement without penalty if the recipient determines that the participant qualifies for an emergency transfer. So you need to have these things in your contracts, okay? You've got to show this stuff to your attorneys and they have to fix those things. We can't do that, for you. So we're just, like I said, we're passing on what HUD has told us. So emergency shelters, this is the final portion of this section. The no individual or family may be denied admission to or removed from the emergency shelter on the basis or as a direct result of the fact that the individual or family is or has been a victim of domestic violence, dating violence, sexual assault, or stalking if the individual or family otherwise qualifies for admission or occupancy. Okay. So, in your essential services like case management, if you're providing ongoing risk assessment and safety planning, you should be making people aware of their rights under VIWA. So, questions about ESG and continuum of care and things like that under this program?
There was a question if you could go into a little more about what adverse action was or
Um,
is.
sure. Adverse actions include a notice to cure for a noise violation, a notice to cure for someone's bad housekeeping that borders on hoarding, a notice to cure because they have too many people in the apartment that are staying, their guests that are staying over their 14-day limit. Other rule breaking, when you give people notices that you have to fix this, okay, and they stated right in the Federal Registry is no limit to the amount of times that you have to give out the Bible forms, that you always do at least 5380, 5382, and we suggest as a best practice that you also do the emergency transfer request, the one or two pager, the 5383. So, so adverse actions, evictions, anytime that if you can add the word adverse to what you're doing, these forms go along with it. So service providers, we have to understand clients' goals and experiences when VIWA protections might be available to the client. Know where to refer these clients to. So we do a lot of work with the YWCA, and if somebody would call us in Miami County, we might refer them to the Family Abuse Shelter to start doing safety planning. So interact with housing providers and help develop lists of local shelters, counselors, and advocates. The and then educate clients on VIWA housing protections, and the how to contact HUD or local people. One of the things that we found was that people don't understand them. So a woman moved into a home with a Section 8 voucher, and she was in some type of a moving program that it was paid for by the Public Housing Authority that uh, uh, issued the vouchers. And she called up them at the end of the first day of moving and said, well, the movers came and they only moved half my stuff in and they threw it around. They were saying very nasty things to me. They were broke one piece of my furniture. I want to trigger my VIWA rights. And so they called us and we were like, oh no, she wants to trigger her fair housing rights because those movers, okay, are covered under fair housing. So anytime a public housing authority or a company has vendors, whether they're people mowing lawns, putting chemicals down, doing HVAC, and moving furniture, we have a responsibility for those vendors' actions once they're dealing with our clients. And so, under the Fair Housing Act, that type of harassment by a vendor needs to be terminated by the public housing authority. And so we said you need to call them and tell them that they need to bring some other movers, to finish this move and to do it right. It was supposed to be done in one day. Now it's taking 2 days. And have to do something to correct their actions. So our obligations under the Fair Housing Act are always to take corrective action, whether it is a vendor on tenant discrimination, whether it's tenant on tenant, an outside perpetrator. We always have that obligation to take corrective action under the 2016 regulation published by HUD for harassment in housing. So that is where, so they explained that to her, and she ended up filing a case against them. And the Public Housing Authority helped her with that. We helped her with that, and it ended up being just between her and that vendor, and everybody else was taken out of the picture. So the always, when someone comes to you and says, "I want to do this," help them, and you might have to educate them about what law you're helping them under, because she didn't realize, she thought it was all harassment. She didn't realize that FI was just domestic violence, dating violence, stalking, and so forth. So that was a great lesson to us to tell everyone that even though you explain all of this, sometimes it takes a while for people to understand exactly what it is.